Hi guys, Mark Dawes, NFPS Limited, and it's the 29th of October 2013, and I want to talk to you about a case that's recently hit the headlines, which involves a school and a third-party company. Now, the case in question highlights the school's responsibility with regard to what they call now a non-delegable duty of care. In other words, a school cannot delegate its responsibility to third-party companies and then actually walk away from the responsibility that it owes to the pupils in the school. Now, in this case, a young girl who was at the school at the time suffered a trauma during a swimming lesson and ended up with permanent brain damage. Now, the school contracted out the swimming lessons to a third-party company, and therefore the school's argument was that it wasn't responsible because it had delegated the responsibility to a third-party company, and obviously some responsibility rested with the swimming pool attendants as well. But the Supreme Court have just ruled that the school has what they call loco parenti, so the care of the child whilst they're at school, and it has this non-delegable duty of care, which means it cannot delegate responsibility to a third-party organisation and just walk away from it. So the school was negligent in its duty to protect the child, which resulted in the child being injured because it delegated the activity, in this case a swimming lesson, to a third-party company. Now that brings me on to this. In this document here, the Management of Health and Safety at Work regulations, and these underpin the Health and Safety at Work Act, it states quite clearly in the introduction who has a duty of care to who and about this non-delegable duty of care. And it says this, it says, if people working under the control and direction of others are treated as self-employed for tax and national insurance purposes, they may nevertheless be treated as their employees for health and safety purposes. It may therefore be necessary to take appropriate action to protect them. If any doubt exists about who is responsible for the health and safety of a worker, this can be clarified and included in the terms of a contract. However, remember, a legal duty under Section 3 of the Health and Safety at Work Act 1974 cannot be passed on by means of a contract, and there will still be duties towards others under Section 3 of the Health and Safety at Work Act. On that basis, what this means is the Act of Parliament, the law, the Health and Safety at Work Act in this case, states that a duty of care to someone else cannot be contracted out under Section 3 of the Health and Safety at Work Act. And that was the basis for the Supreme Court ruling in the case of the young girl that was brain damaged. Okay, so what has this got to do with you? Well, if you're a school or an education authority or a trainer, anyone that you subcontract activities or work to, you are ultimately responsible for. And that means, in our world, restraint training, if you are a school, for example, basing this case on the fact that it happened in a school, you have a non-delegable duty of care to your pupils. That's been established by the Supreme Court. If you then choose, as the headmaster of that school, to implement a system of training for physical restraint or physical intervention, whatever you wish to call it, you cannot then step away from that and say, if anything goes wrong, it's nothing to do with us, it was the people who supplied the training who were at fault. Because if the training is flawed and you fail to check that, and that results in a member of your staff trained in that system injuring a child, either permanently, as in this case, or temporarily, or God forbid, killing them, then you as a head teacher of a school, based on the ruling by the Supreme Court, have a non-delegable duty of care which cannot be passed on by means of a contract. Now this is really, really important, and although I'm talking about schools, because that was the nature of this case, it applies to every area of our work. So if I, as a training provider, subcontract courses out to other instructors, and they go away and they injure someone, then technically speaking, I'm liable. And this applies exactly and directly to you as well. So whether you're a school, a care home, an NHS trust, a secure training centre, secure training establishment, a prison, police, a private security company, it doesn't matter. Whether you are a venue subcontracting work to door supervisors, you as the venue owner, under that Supreme Court ruling, which is now a case law precedent, cannot walk away from that and say, it wasn't my fault, they're the trained people, they should know what they were doing, because you have a non-delegable duty of care to the people in your care. And this applies to the people on a subcontract basis, so security officers, door supervisors, teachers, teaching assistants, so on and so forth. This has got massive, massive implications. So that's the Supreme Court ruling. I'm going to put a link to one of the actual press releases on this which appeared in the national press, so you can read it below this video. And please, this is so important, I'm going to ask you to do one thing for me. Would you please share this with all of your friends on Facebook, on Twitter, on LinkedIn, and pass this around? Because if people don't know about this, they could be left liable without knowing. So I urge you and basically ask you very respectfully just to click the share button on this and share this with all your friends on Facebook, Twitter, LinkedIn, and any other social media site you care. Thanks ever so much for listening, and I'll speak to you shortly.